We have, good morning, this is Judge Garrett. We have a number of things on our agenda today. We have a guest, and welcome, Ms. Guevara.
Thank you, Judge.
Yes, we'll be getting to your presentation in just a little bit and are looking forward to it. We also have some comments from Andrew Peterson, who's going to have to leave us a little early. Andrew, you're here till 1 o'clock, right? Okay. And let's see.
Can we take
Freeman, is there anything you'd like to add?
Could we take the agenda down just so I can see people? Thank you for putting it up earlier, Jill.
Yes, thank you. And thank you for taking it down as well. Okay, that's better. Judge Freeman, is there anything you'd like to add to our agenda for today?
Nothing to add, just welcome to our guest.
Okay. And in view of the fact that Dr. Peterson is going to be leaving us, I'd like to get to discussion of your topic first, Dr. Peterson, Andrew Peterson. Where are you on putting together numbers for us?
Sure. So I have jail data together with the Allen's data and the administrative office of the court's data on charges filed. And just, it's a process to get all that data together, but we're starting the analyses now. So, the analyses don't happen as fast as I like. It takes time. You got to do it and then check it and recheck it. But working through that now.
What information are you going to be able to give us, and when?
Well, good question. So the goal, I think, is to look at who is getting released, how long they're in, and it'll be, testing this question of release and supervision and the effect of them, validating the risk assessment instrument, the PSA, seeing if its scoring matches up well with the Whatcom individuals that come through the system. And that's going to be the bulk of it. And then, of course, checking to make sure that there aren't any issues with disparity, racial, ethnic, especially. So.
And when can we expect to get some, at least preliminary reporting from you? Speaking as one who's not a quick study on numbers, what I'd like to see is material that's either written or can be printed so that I can, print it out and work with it and put in comments and do my own math on the side and all that kind of, analysis. When can we get that information from you, Andrew?
Sure, and I encourage all that, please. But
Sure.
I'd say, the goal would be within the next couple of months to be in that kind of state where I can share something and feel confident in what I'm sharing.
Okay. I may be putting you on the spot here, and I don't mean to do that. You may not know the answer, and if so, that's fine. But do you know, or do you have a sense of what your abilities are going to be in the future to work with our committee? And when I say the future, I mean for both the near future and the long term, but especially the near future.
Sure, no, that's a very appropriate question because it brings up something I want to talk about. So I had discussed this with my boss, and what he would like is because he kind of tries to keep an eye and manage workflows and projects coming in, just so that it's kind of officially on the books and prioritized. If someone from the group could just write him a letter about the it could be an email even, just with kind of the work that you are hoping to see from me, so that he can have kind of a formal, I don't know, evidence, formal something of the request, and work. And so it's kind of on the books. And if anyone asks, oh, what do you guys do with the AOC? Then we can produce this too. And it'll also help him prioritize and keep his boss aware of what's going on. So.
Okay, well, that doesn't seem like a difficult thing. I think I can probably do that or work with somebody else who'd like to collaborate with me to do a letter like that. We can correspond outside the meeting and you can give me contact information and
Sure.
Like that.
Yeah, and then when we have that, then he can help, he has a better eye of what's coming in and what's kind of on the horizon. So then I'll have a better sense of what my availability will be in the kind of short and long term.
Okay. But it's sounding like we can't assume that we've got Dr. Peterson, Andrew working with us indefinitely, because we don't know what the priorities of AOC are going to be in the future. So that makes it all the more important, Andrew, for us to get this statistical information from you as soon as possible so that we have time to discuss it with you after you've sent it to us. So
Sure.
I just would encourage you to focus on that as much as you're able to, because that really is key to the mission of our committee, our work group.
I agree. And I would, Judge Gator, I would phrase it just slightly differently. I think, the availability will be there. It's just, unfortunately, there will be a queue of work projects and, that this project will be somewhere in that queue. So it will happen. It's just a question of kind of when and how that all fits in, because if the legislature comes with something that's, a demand and it's funded, then maybe we have to, put that higher up on the list and some things like that. So it's just, shuffling that list more than me disappearing per se. That makes sense.
Yes. Dave Reynolds, is there anything you'd like to add or ask about the work that Andrew's doing for us?
Nothing beyond what you've asked, Judge. Would the letter go to Carl? Okay.
Yeah.
I have his contact information, so I can help Judge Garrett with that.
Perfect. Thanks.
Okay, Dave, you and I can work together on that one then. Okay. Do we have other topics that we need to address? I guess there is one topic that I would like for us to address, and I'll say it now. And maybe after we've heard from Ms. Guevara, we can get back to discussion of this. But I really want our work group to do some heavy brainstorming in the next couple of meetings about how we see pretrial services functioning now and in the future. And obviously we're going to be looking at the short-term future too, but we're hoping to have created an institution here, and that institution will have to deal with changing times, including the impact of a new jail if that's passed, or the impact of not a new jail if it's not passed. So all in all, we've got our work cut out for us in terms of envisioning the future of pretrial services. But having tantalizingly dropped that fascinating topic in front of all of you, I'm going to pull it away now and ask instead that we hear from Ms. Guevara. And Ms. Guevara, I don't want to make this real formal, but it looks like Maya may be able to introduce you and tell us a little bit about your background in the Pretrial Justice Institute. And then we're most interested to hear from you on pretrial topics. We're hoping that you can talk until maybe 1:10 or so our time, which will give us time to finish up our meeting after you've shared your knowledge with us. Okay, so I'll turn it over to you, Maya, in case you have any comments you'd like to make, and then you can turn it over to Ms. Guevara.
Well, thanks everybody for allowing us this time to address this important topic. I just became familiar with the Pretrial Justice Institute and reached out to Megan, who made herself available. I think that Megan would appreciate hearing very briefly from each of us, just so she knows who her audience is before she begins. I told her I expected she'd have about 15 minutes to address us and then we could have questions, but you have a little more time. So if you're able to speak longer, please have at it. But I expect that we will have questions. I'm the Chief Deputy at the Public Defender's Office. I'll just call on the next person so we can do introductions that way real quick for her. Dave Reynolds.
I'm Dave Reynolds. I'm the Director of Superior Court. Judge Freeman.
David Freeman, I'm a Superior Court judge.
And I'm Deborah Garrett, and I'm a retired Superior Court judge. And one of the members of this group, there are several of us who've been here since the inception, which means that we've seen pretrial services change a lot, from no pretrial services to getting some pretrial services, then dealing with the COVID situation, which changed everything. And now back to a sort of normal, but not really normal, partly because we have a terribly decrepit, low capacity jail, which is not a good place for people to be. And so my concern is that if jail space is increased, incarceration will increase as well. And so that's something that we want to be focused on, so that we're sure that we're incarcerating only the people who really need incarcerating pretrial. So that's me. Andrew?
Andrew Peterson, I'm a researcher with the Washington State Center for Court Research and the Administrative Office of Courts.
And Stephen?
I'm Stephen Gockley. I'm a retired civil legal aid attorney, but I've been the co-chair of the Incarceration Prevention and Reduction Task Force for a number of years. I'll just add that thanks to Maya circulating the notice, I was able to watch the Zoom webinar that Megan did with a panel of speakers, which I found tremendously informative and stimulating on willful fleeing. We have the recording. And Maya was on that, also asked a number of very good questions in the chat. So probably both of us have access to that recording, and I'd really recommend that the work group members take a look at that conversation.
I suspect we all have access to it, or if we don't, I'm sure Maya can resend the email she sent me with a link. I watched that presentation also and found it really quite helpful and gave me some interesting ideas.
Wonderful.
Barry Buchanan? Oh, I'm sorry, Megan, were you going to say something?
I was just saying that's wonderful that you had a chance to watch it and you enjoyed it.
Good. And Barry?
Yeah, hi, Megan. I'm Barry Buchanan. I'm chair of the Whatcom County Council, and I led a project we call the Justice Project. Stephen worked on that with me very closely, in which we created a needs assessment for our criminal justice system. Then we turned that into an implementation plan that describes several projects, a number of projects that would be beneficial to the system. And then we have now put together an ordinance that's in the introduction phase right now to be heard by the public next week. That would put a measure on the ballot for 0.2% of a sales tax measure for
Just a second, I'll be right back.
for this work that we've done called the Justice Project. So anyway, that's me. Alan?
Yeah, Alan Epps. I work in pretrial services for Superior Court.
I think Bruce might be next.
I'm Bruce Van Glupt. I'm the District Court Administrator and the Director of the Adult Probation Department.
The only person or the party I think that may be missing from this discussion is the prosecuting attorney's office, unfortunately. So other than that, I think this is generally the representation we have at this meeting.
Wonderful. Thanks so much for taking time to introduce yourself. So I've got a sense of who's in the room. And should we wait for Judge Garrett to get back before I get started?
Maybe just a second. It seemed like she would be right back. I think the other person we're missing is one of our lead caseworkers who typically comes to provide some sort of like on the ground insight.
Bill
Anyone?
Langdon here, and just to let you guys know, I think I forwarded you the correct link to the webinar that Maya and Stephen just referenced. Maya, let me know if that's the incorrect link.
Great.
So
I'll
that
have
will be in your inboxes.
I'll have a look.
I am going to share my screen. I did put together a few slides for this afternoon. Is that showing up for everybody?
Yes.
Wonderful. All right. Well, thank you again for the opportunity to speak with you all today. I did prepare a short presentation, but please feel free to interrupt me as I'm talking with questions, and I'll definitely make sure that I leave ample time at the end for conversation as well. And again, my name is Megan Guevara. I'm an executive partner with the Pretrial Justice Institute. I am located outside of Denver, but our team is spread across the country. And PJI has been around for almost 50 years. We were founded in 1977, and through that time have always been working exclusively on the front end of the criminal legal system. And this is our mission statement. Our goal is really to figure out how to end mass incarceration in the United States by limiting the entry of folks into the front end of the criminal legal system. And we work mostly at the local level and with community members and public officials looking for the carceral solutions that focus on equity, safety, and well-being. And we do that through a variety of services, publications, and educational presentations, as you have all seen, as well as local technical assistance and community and advocacy campaigns, as well as research partnerships. And so I'm here to talk about willful flight, but work in all sorts of areas around pretrial justice. So any questions that I can answer for you regarding some of the other priorities of the committee, I'm happy to do that as well as we talk today.
Well, I do have one question, and that
Yes.
is, I take the term willful flight to mean someone not coming to court by choice, choosing not to come to court, as opposed to having unforeseen barriers to coming to court. Am I understanding the term right?
Yes, that's the way that we view it as well, of really getting at the difference between people who have barriers in their life or other circumstances that prevent them from making it to court, or just have difficulty tracking their responsibilities and need some support to be able to get back to court, versus those folks that are actively trying to evade prosecution.
And when
And
we're
also-
talking about flight, we're talking about effort. I mean, it sounds to me, just based on the presentation I saw, that when we talk about flight, we're not really talking about people fleeing the jurisdiction. We're talking about people not coming to court, whether they stay in the county or the state or whatever. Is that right?
Yes, it could be both. It could be folks that are, geographically fleeing, that are no longer able to be accessed, or it could be folks that are making an active choice not to fulfill their court responsibility. So it could be somebody that is available but is choosing not to come to court, or it could be somebody that is making themselves unavailable for prosecution.
So it's not so much flight, like physically fleeing or leaving. It sounds like it's more like willful failure to appear in court. Is that
Yes,
right?
yeah. And truthfully, there's not a really clear legal definition, because there has been so much confusion in the terms, over the past 200 years. So that is something that we are hoping to be able to help to clarify, because as we look through the legal literature, really it's been the difference between the willful question, the difference between someone whose intent is to evade prosecution versus someone who's did not have an intent to evade prosecution and has another reason why they did not appear in court on a particular day. And also the difference between someone missing one hearing over the course of a pendency of a case, but still being available for the resolution of that case, versus somebody who, flees before a trial or flees before a sentencing hearing and does not allow a case to be resolved.
Mm-hmm.
And though we do not have a lot of data on willful flight, because most jurisdictions don't differentiate in their data systems between willful flight and any other types of failure to appear, anecdotally speaking, and as we look at the information that we do have from things like validation studies, that willful flight does seem to be a very rare event, that for the most part, you have folks who are missing court appearances, but at some point they come back, or at some point they're found and they're still able to see their case through to resolution.
Okay.
And the reason that PJI chose to take on this issue is exactly for the reasons that you're raising, Judge, that in general, we're not very precise around the way that we define flight in pretrial justice. And we look instead at what is the likelihood of any failure to appear in court. And when bail determinations are made, the information that is made available to the court is usually about history of any failure to appear. And so that increases the group of people that is potentially going to be detained pretrial or is potentially going to have more onerous conditions put on them for pretrial release, because there is a risk of any failure to appear, even though many of those people are still likely to see their case through to resolution.
Okay.
And as you all know, up until the 1980s, when public safety was added as a legal consideration for pretrial detention or denying bail, that question of court appearance was the sole reason for bail decision making in the bail process in the United States. And so, as you all know, and as you know, if you've read the paper or you have watched the recording of our webinar, that people miss court dates for a variety of reasons. You all see it every day: transportation, childcare, needing to get to work, mental health crises, other cognitive issues that make it difficult to track the court process. And there's a growing recognition in our field that which is often called non-appearance, of missing a court appointment, is often more a reflection of the circumstances of someone's life as opposed to a willful desire to evade the court process or evade prosecution. And that when we put programs in place to be able to address that non-appearance, like court reminders, rides to court, flexible docketing structures, that those have shown great success in being able to get people back to court to resolve their case. And the Bail Project, which collects data nationally on the clients that they work with, who they've bailed out and then offer supportive services to, have a more than 90% success rate in getting people back to court when those supportive services are offered. So the question that raised for PJI was, what does that mean in terms of the standard that we're using when we make initial bail determinations? And that question was also driven by the pending change in Illinois' law, which does include a willful flight standard in statute, but decisions haven't been made yet about what it would look like to actually operationalize that kind of standard. And so we would like to be able to figure out what would a willful flight standard look like operationally if courts had information at initial bail determinations to try to assess not just whether somebody would miss any court date over the pendency of their case, but the likelihood that they would evade prosecution. And I did think it was interesting when Maya reached out, because in most parts of the country, you're not next door to an international border where people may actually flee the country, but I don't know if that call comes up for you in Whatcom County. So we are trying to work right now to figure out what would that look like to consider a more narrow willful flight standard. And we hypothesize that that standard would increase pretrial liberty while still ensuring that cases are resolved. And that it would also be in closer alignment with constitutional principles and Supreme Court precedent around liberty being the norm and detention being the carefully limited exception, as well as some prior court decisions that do state that the goal of bail is to make sure that people are there to face prosecution, but not necessarily to punish folks if they are missing individual court dates. And I asked at the end of the the online event, if there are any places that might be interested in exploring this test of a willful flight standard. We do have a pending proposal with the federal government right now to be able to provide some technical assistance to a jurisdiction that we would like to work with. And so we're having conversations with places across the country over the course of the summer as we're waiting for that funding decision to come down to see if there are local places that might be interested in being a partner with us on this work. And this would be a multi-year technical assistance effort looking to work with the courts and community partners as well to define and test a willful flight standard. And that would be where we would get into the questions of, okay, you know, how do we decide the intent of someone who doesn't show up for court? You know, how would we define willful? If someone doesn't appear for one court date that we might define as non-appearance, if they then don't appear for 6 court dates, you know, at what point does it become willful flight? And how does that fit in with state statute and court rule as well, to make sure that we develop a standard that is in alignment with local laws. And we also want to explore what is the impact on court culture and operations of putting such a standard in place. So for example, we would likely need additional supportive services like court reminders to help people get back to court if we did increase release rates. And we'd have to consider the impact on docketing, on and just the question of how does the court respond when folks don't appear, and how would this change potentially what those responses might be. And then we'd also be looking at data systems as well, recognizing that no place right now has a way that they're documenting willful flight as opposed to failure to appear. And what would it look like to set up a data system that does make that kind of recording? How does it relate to the way that you're using warrants and the way that warrants are being documented so that judges have the information that they need in order to make a willful flight determination? And then we hope to be able to put that standard into place and do a pilot test. And that could be across a full jurisdiction. It could be in one courtroom. It could be on specific dockets, whatever makes most sense to be able to assess the impact. And then we have a data and evaluation partner that we're working with as well, who would be both helping with data capacity in the local jurisdiction so that it increases your capacity to be able to collect that data over the long term, as well as collecting the impact data and being able to offer back a report on what the impact of testing that policy has been.
Can I interrupt with a question?
Please.
Here? And if it's premature,
Pause this.
I apologize, but Judge Freeman, I'm going to ask you to talk a little bit about the measures the court has taken recently to deal with people not coming to court. I mean, back in another time when I was on the bench, which was only until 2 years ago, if people didn't come to a court hearing, and there were many court hearings before trial, if they didn't come to a court hearing or contact their lawyer and sign an order in advance, they would be noted as failing to appear and often prosecuted for the felony of bail jumping. And that's changed a lot. And now my sense of it is that the court has offers several opportunities for a person who misses a court date to make up for that. And I know that there are far fewer court dates that require mandatory appearance, but Judge Freeman, maybe you could just describe that briefly.
Yeah, on the local level, I would say it started with our pretrial services, and they do get, every defendant gets push notifications for upcoming court dates, is my understanding, and those come through district court. And then those placed on pretrial services may get additional contacts with Alan as far as checking in and court dates. At the state level, there was a substantial change in 2022, I think, or 2021, that had to do with warrants. And I mean, arguably, folks are still supposed to attend things like status hearings. However, warrants cannot be issued unless they've been ordered to be there previously. I think our general courtroom approach in Whatcom County has been not to order that unless somebody has continuously failed to appear at the one hearing that is mandatory, which is the trial call calendar. And so if somebody doesn't appear to status, it gets set over for a trial call for them to either appear, or if the parties work it out and they've been in contact with their attorney, a new order can be entered. So as long as they've had contact with their attorney prior to the status, they're not even required to be there. Orders can be handed up generally. So really, we're down to the one trial call calendar, and that is if they've not been in contact with their attorney, if they've not appeared at the status, then that's the only time that generally warrants would issue.
Okay, so the reason I asked for Judge Freeman to update us on that is that I just want to know if those are the kinds of measures that you're talking about. And it seems like we give defendants a second chance, even if they miss the critical hearing. And these are measures that we've developed over the last couple of years, partly through this committee and partly through state law and partly through our local Superior Court judges anyway. I think, I won't speak for district court, but I think they face similar issues. But an effort by the judges to try to end sort of arbitrary cruelty and just look to impose consequences on people who really deserve them, as opposed to people who've just, had a screw up in their daily lives. So the reason I ask you about this, Ms. Guevara, is I want to know if these are the kinds of measures you're talking about, and if so, if it looks like we're headed in the right direction there. And so go on, please. Yeah.
Yes, no, absolutely. I think that those are the kinds of stepping stones for folks. Once an initial bail determination has already been made, I actually had not been familiar with the Galinas case until Maya shared it with me. And so I appreciate that recognition that you have around the difference between different types of hearings and what that means in terms of appearance and the issuance of warrants. I think that's a great step, and recognition that people who miss a court date don't necessarily all need a warrant issued and don't necessarily need to face significant consequences for that. And I see those as really great stepping stones to the types of policy change that we're talking about here. Of where we see this going is that, okay, if those folks were to subsequently get arrested again and be back before the court for another bail hearing, do you have the information that you need to be able to differentiate in terms of their history to say, this is somebody who in the past has tried to evade prosecution, and now as we're making decisions about their pretrial liberty, we need to consider that past risk? Or is this somebody who in the past, had a screw up, had a barrier to being able to get back in court, and we don't need to hold that against them in terms of making a determination about their future liberty, and instead, need that court reminder program or potentially need some other type of support? And I think it would be a court system that has taken some of those initial steps that would be in a better position to put this kind of refined and narrow willful flight policy in place, rather than a system that hasn't already had some of those shifts in policy and culture.
Okay, please continue.
Thank you. And I see Maya and Stephen have hands up as well.
Oh, I didn't notice. I'm sorry. Go ahead.
I'm going to jump in really quick just to say that I recognize this, and I think there was some email exchanges about this, and Alan responded where I was saying, well, pre Galinas, like when we're at first appearances and the commissioner is making a decision on bail, our attorneys are saying, well, any failures to appear, warrants that issued before 2011 really should be taken with a grain of salt, because we don't even know under the current appreciation for appearance whether these were court dates that they were even needed at, and sort of trying to weave in that willful flight, but not very successfully or meaningfully, because we don't have the real information to provide the court that this program is trying to build in and create for the judicial officer who's making those decisions. And I know Alan commented, I think in an email, that he's not counting failures to appear, he's only counting warrants that issue. And I am not sure exactly how he's doing that. And the measure of, I guess I have some question about the measure of discretion that goes into that and whether that affects the efficacy and sort of integrity of our pretrial screening tool. Sort of getting off on a side thing here. Sorry, Megan. We don't have to discuss that, but I think it's something we should look at maybe. So I'll hand it over to Stephen for additional comments since mine wasn't really a question. Sorry. Thanks.
I just wanted to bump up on the ladder, the last bullet that Megan showed, which is the ability to partner on their pilot project. I think the PJI inquiry and campaign is completely aligned with some of the values that we've had in this work group since the Vera Institute report. Frankly, I think we've been fumbling our way through largely with our own resources, a little bit of help from Andrew Peterson and the Administrative Office of the Courts. But I think we're at a point of opportunity where so many of the pieces that PJI would offer a pilot partner in this would be really important. As Barry will attest, the council and the county executive are about to hire a couple data specialists because we've identified data inadequacies across the system as a problem area for policy reforms. We've got a new sheriff coming into office next year. Not that Sheriff Alfo has been an obstacle to any of this, but some fresh eyes would be a good place to look at reevaluation. I think one of the things I took from Megan's webinar was if you're not going to be penalizing non-willful non-appearance, you need to be packaging a whole array of support services around those people to help them comply with court appearances and other release conditions. And that's consistent with what the implementation plan Barry was referring to as calling out. So it'd be helpful to know what kind of support services might be most effective in supporting a policy change in this direction. Also, I think the original intent of this work group was to de-emphasize and reduce the frequency of imposition of bail at all. I know we're still in conversation with judicial officers about how far to go on that, but it would be helpful to have the outside perspective, the outside expertise, and some of the resource supports that PJI seems to be offering in that pilot project. And I'd just like to strongly encourage us to consider raising our hands and volunteering to be considered for a partnership in that.
Well, let's get back to Megan's presentation, but Megan, we will ask you to let us know more about what we need to do to proceed with this. And I see that Judge Freeman has a hand up. Thanks to Maya, I finally noticed. Judge Freeman, go ahead. I think you're muted, Dave.
I'll try to keep this really short. One is a quick point I have to make, and the other is a question I have for you. First, I don't want us to get too into the weeds on our court rule regarding appearance. We did have case law change in Galenas that had to do with a bit of a different issue when it came to district court authority. And then ultimately our Supreme Court changed our Superior Court rule. So it's kind of an example, and what I'm leading to here is that even as a judicial officer, even if we were to negate certain time frames, it poses a very difficult question for us on how to apply the FTA, because it honestly, a district court case could be viewed differently than a Superior Court case when it comes to the FTA, just based on case law. That leads me to my question, which is, how could a local jurisdiction implement a system such as this when we are entirely dependent on our state data system for those questions? And so I just have just not sure how that could happen.
Yeah, that is a challenge, and having heard the first part of the conversation here today, that for you to have to wait for data to come down through the state and to be in what sounds like a very long queue for your data to be prioritized has got to be a significant challenge. And we would, as part of this project, be able to offer capacity building in terms of, like, how do you set up the data systems for something like this, and what would be the measures, what would be the best way to track them. But it would, in the long term, really require that you've got somebody locally that's able to put those systems in place, and then be able to turn that data around to you all on a regular basis, in order so that it can help to inform your decision making. So I'm glad to hear that there is, local conversation about being able to build that capacity, because it's got to be very, very frustrating for all of you to not be able to get that information in a timely way, to understand how the decisions that you're making are in real time impacting the flow of cases through the court, and then the ultimate impact on the jail population as well.
True. Yeah.
And
Megan, I
part of
told
the
110, but you've been interrupted many times. So why don't you continue with the floor? Yeah.
No, and the presentation was short for that reason, because I absolutely wanted to be able to have these kinds of conversations. So I will say that part of the funding proposal we did put in for this did include a half-time position in the local county, over the 3 years of the project. So there would be some resources that you could all decide, what is the best way to use them to be able to support the work. But of course, that doesn't help you after the 3 years are up, in terms of being able to support capacity in the longer term. But
if we set up systems for gathering data, then maintaining it, it's much easier to maintain a system than it is to establish it. So, yeah.
And if you're all interested, I can send you the longer document that describes the proposal, that describes the technical assistance that we do plan to offer, that can give you a better sense of both what we would be asking you to commit to, as well as what we would be able to offer. And the first stage of that work is system assessment work. So that would include reviewing, what are the legal frameworks that we're operating within that would impact the development of a policy, being able to do some flow analysis of how your pretrial processes are currently working, and some observation of what pretrial decision making is currently looking like. And so hopefully that would be beneficial to you all, both in terms of your willful flight policy, as well as, broadly the work that your committee is doing as you're thinking about your broader pretrial policy. Then we would be looking at, who needs to be at the table to have a conversation about what this pilot policy would look like. And we would get into all those questions that you all have been raising around, okay, what's the difference between district and superior court? Are we piloting this in both places, or is it more relevant to one or the other? Are there distinctions that we need to make? What are some of the operational challenges that are coming up for all of you? And of course, we're not going to be able to develop a perfect policy, but we would hope to then develop a policy that would be workable, that is legal within your current framework, but does attempt to take all these considerations that you've already talked about around, what do you consider to be non-appearance versus what do you consider to be willful flight, and then put that policy in place for a 15 to 18 month period, during which we would be collecting ongoing data. And then we would be able to turn around quarterly reports to you about what we're seeing in that data, as well as a final report about what it looked like the impact of that policy was, for you then to make decisions about what it would mean going forward. And then we would be sharing those lessons learned with other counties who are facing similar challenges, and hope that our pilot jurisdiction will be a good learning laboratory for the rest of the country.
Well, one thing we all need to remember is that we're an advisory committee. We don't get to run the court. And ultimately, these are decisions for the judges to make, guided with the input of the commissioners as well, but it's the judges who are in charge of the court. So let me put this to you, Judge Freeman. Do you think if we pursue this further, would there be interest? I don't want to assume. What do you?
I have a lot more questions before I would commit to that. I have a lot of interest in the data collection side. my fear is on the implementation side at a local level. I think the goal is one that there would be interest in, but just the way our data system is used right now, I see multiple hurdles to that at a local level. I mean, the simplest being that even if we update, and again, for data collection, this is a great idea and a good comparison to other counties based on what is willful and what's not. But when we actually implement it, if we try to do that at a local level, it means us treating those local defendants that have had FTAs in Bellingham Municipal Court, treating those FTAs different than those in King County Municipal Court in Seattle. And I just see some significant questions I have as far as implementation. I have a lot of interest in the data collection and the showing why the importance of willful versus just the non-appearance. But actually getting to the second step of implementation seems like a much more difficult thing at a local level versus a state level.
Would it make
And
sense?
I'm, sorry, go ahead. Mike.
Just, Your Honor, would it make sense for the judges to hear from Megan?
So that was going to be my follow-up. Before I take it to the judges, I'm probably going to have a number of questions for Megan first so that I can help bridge that gap. And then once I have the discussion with the judges and have those questions that I have on hand answered, then I think we have judges meetings every 2 weeks. They're currently on Thursdays. They'll be moved to Wednesdays at noon. And my plan would be to bring you in to a judges meeting where you can talk to the judges and commissioners and get some of their questions asked. But I think I better do a little bit more homework first. I did see the presentation, but I think I have some more questions before I can adequately bring this to my colleagues.
Okay, and fair enough. Stephen, you had a hand up, or do you?
Yes, I do. This may be one of Judge Freeman's questions already, otherwise I'd add it to the list. And Megan, what you've presented so far seems to be oriented toward reforming a bail-dependent system. And one of the Vera Institute recommendations several years ago was for us to adopt a statistically validated pretrial risk assessment tool. We spent years looking at them, finally settled on the Arnold Ventures public safety assessment. We tweaked that even so that we are scoring new violent crimes rather than just any crime. And so we would need to tweak their criteria and probably revalidate for this. But I'm just wondering, using a risk assessment tool, does that complicate? Does that interfere? Is that something that PJI is contemplating trying to factor in as you work on these pilot projects rather than just a bail system?
Yeah, so it definitely does complicate it, but it's a complicated question, so we're okay with that. Virtually all risk assessment tools that are in use right now are designed to measure any failure to appear. And so it would require a change. And PJI, generally, our policy is not in support of risk assessment tools because of the racial bias that is that's built into the data. But that is one of the questions, if there could be a risk assessment tool that's looking at much more narrow criteria, does that, change the way that we are that we're building objective decision making? Because we know that we do need some sort of criteria that are in place. It's just a matter of what does that need to look like. So that would be one of the questions that we would want to ask is there a way to change the way the risk assessment tool is being used in order to narrow it to a willful flight standard, or how would the implementation of this policy impact the way that you're currently using the PSA? Are there questions that would, more initial screening questions that would lead to more folks being released on their own recognizance, and then the risk assessment tool being used more narrowly to determine how you are conditioning folks that you're going to be releasing on conditions that may or may not include a bond. So I think those are the kinds of questions that we would be diving into. And I think those are questions that we will run into in many jurisdictions around the country, because there also are not any examples that we can look to yet of places that are not using money bond and have that more narrow list of criteria in place.
Are you, as part of your advancing this, are you in conversation with any of the creators of the risk assessment tools? Because yes, it would be a systemic change in that piece of the puzzle also. You know, we're aware of PJI's opposition to those tools. We ended up, after a lot of discussion, coming out in favor of the PSA as opposed to the totally subjective individual judicial officers judgment as being a little more reliable. And Dr. Peterson did some validation work for us on top of the general PSA validation work, but it might prompt a change in the tool itself, but it would be hard to do that individually without a very extensive and expensive revalidation process.
Yes, yeah, we do not anticipate that the first step in this implementation is going to be able to get us there. But, you know, as we talk to some of the researchers, you know, folks like Sandy Mason, that we all seem to be on the same page that the risk assessment tools that we have now are far from perfect. And then the question is like, well, is it still better than the other options that we have? And so it makes sense to put it in place. Where we're trying to get with our research is like, what's the other option that we could be offering so that places don't have to choose between risk assessments as they currently exist or systems that are based on money. We know there's got to be a better option out there, but we need to be able to develop it and test it. So I think that there is definitely the possibility that there could be a narrow set of criteria that could contribute to that objective decision making related to willful flight that then can help to get away from some of the problematic issues we have with the data that are going into the current tools. And that's going to be further down the line. But I think that the researchers who are involved in risk assessment development and researchers that are just involved in the criminology space that have taken positions on risk assessment are very interested in exploring those options as well. There isn't anyone that's like, nope, we've got it all figured out with our current risk assessment tools and we're going to stick with it if we can find something better. I think that a lot of folks are interested in what that next evolution is going to be.
That makes good sense to me personally, because I just don't see how a judicial officer can make responsible decisions about pretrial conditions, whatever they might be, without knowing something about the person's record and you know, the person's past. And so it seems to me that there's a problem with lumping all the FTAs together. And if it's possible to break down that data, it makes for more responsible decision making as well as more responsible risk assessment tools. But
yeah, that is our hope, that we'll be able to give you better data, and then that better data will help with making those more refined decisions.
Okay, that makes sense. Well, I for one would be interested in exploring this potential further. The potential for partnering with the Pretrial Justice Institute. And this is not a binding vote by any means, but could those of you who are interested in pursuing this further raise your hands, just so I know I'm not out there in the wilderness? Good, good. I think
just because I clocked in late, so I apologize about that, but
okay, but that's fine. And nice to see you, Adam. Thanks for being here. Sorry you were late. And Alan, I didn't get a chance to say hi to you either, but hi.
Hello.
Okay. Why don't we circulate, Maya, why don't you work with Megan to circulate some contact information so we can establish some correspondence and look into this further. I think that we're at a pivot point with our pretrial services unit. I mean, I think that's clear to everybody. Probably it's not more clear to anybody than to Alan, who's right in the in the eye of the storm. But we're looking at how pretrial services as a unit can function most effectively in the current environment, which is quite different from the environment in which it was created. And I feel like in many ways we've done the low-hanging fruit with the help of district court and Bruce Van Glubt. We've put together a good system of text reminders. It's not perfect, not everybody has a phone, but it's a start. We've put together a pretrial services unit and we've offered those services to people. We need to know, and you need to know, Megan, this may be true in every state, I don't know. But in Washington, people are presumed innocent until proven otherwise. And so the court doesn't have the power to make services mandatory. So we're also working in an environment where, with the bargaining power that pretrial services has is limited. It used to be that if you don't cooperate, you'll end up maybe going to jail, but people don't go to jail for minor things anymore because our jail is so crowded. So we've got our own local challenges, but the president, I recommend to all the people on the committee that first of all, I'd ask Maya to send out the link to everybody on the committee if you haven't already. I know you sent it to me, but the discussion among the various defense attorneys in the Pretrial Justice Institute presentation is really very good and caused me to just come up with some good ideas and some, I think, good questions about how we might want to look at this. So the mechanics of the partnership, a partnership with PJI, is that something we'd be looking at over the next couple months, or is there a deadline coming, or where are we on that?
We anticipate hearing about the funding decision in September. So we've got a couple of months to be able to, answer questions. And then at that time, we'd be able to let you know, yes, we do have resources to be able to bring to the table for this. And then that would be when we would be looking to be able to make a final decision regarding partnership.
Okay.
And of course, it's federal funding. So things always happen a little bit slower than you think that they're going to as well.
Yeah, well, that's part of life.
Judge Perry, we've got a couple of hands raised. They've,
Again, I did it. Okay. Let's see, Judge Freeman and Stephen, apologies to you both. Go ahead. Judge Freeman, why don't you go first?
I don't even remember why I raised my hand now, so I'm gonna
Maybe you
lower
just
that.
didn't
I'm
take it
sorry.
down from the last one. Stephen, how about you?
Well, I do, only because I have a little short-term memory left. I guess this is directed at Judge Freeman. I certainly wouldn't want to intrude on the judiciary's control of this process, but I would just like to emphasize, I think this is really strongly in line with the history of the task force and what we've been working on and working towards. So if I could throw any weight on the side of jumping in and working with PJI as you talk to the rest of your team, I would do that. I also would say, I assume that partnership would entail a lot of conversation back and forth in shaping what that work might be. So I don't think all the questions that the judicial officers have now would need to be answered to jump in. And lastly, we'd get a report which may look problematic on our end for implementation, and we wouldn't have to adopt the recommendations. That's all they would be coming out of the pilot project. So it seems like
information.
Yeah, it seems like an opportunity to answer some questions, to get information, to get creative ideas from outside perspectives. And I think there would be a lot of positive reason to do that.
And I'll just very briefly respond to that because as I raise my hand, I am very interested in the partnership as well. But like I said, my interest is that us being a pilot, as far as information gathering, my fear is the implementation side, because I just don't see how a way it could be implemented at a local level based on our state data systems without treating certain individuals differently than others. Because if we're gathering the data in isolation, it means we have the data for folks that have FTAs in Whatcom County, but we don't for any other county in Washington, at least. And I do, they're calling me out to court. I'm sorry. but it's, and so those are my questions mainly for Megan that I'm going to have hopefully answered, whether that piece, if we can get up to the implementation part, and we would still be a valid partner for the project. So.
Great.
That's fair. Thank you, Judge Friedman. We'll be in touch.
I'm sorry, I have to.
Thank you, Judge.
Yeah,
Thanks.
take care.
And I'm sorry, I have to go too, but I'm really excited. I mean, I love the way you framed it, Judge Garrett, about the need for us to dive into some bigger picture. Where are we going here? And next meeting, I guess. Thanks. Thank you, Megan.
Yeah, you know,
Thank you.
homework for those who haven't done it yet. It would, for those of you who can, please watch the presentation. I'll remind Megan that, I mean, I'll remind Maya that we want her to send that out to the group, and we can work with Jill, but it really is a good presentation. So if you watch it, you'll hopefully have some good ideas for our next meeting, which is the first Friday in August. Megan, thank you very much for meeting with us. We've appreciated your input, and it's an exciting time. And, you know, times of change are stressful and exciting at the same time.
Yes.
Yeah.
Thank you very much. And I'll just mention in closing that we support local work in a variety of ways at PJI. So it'd be awesome if this project seems like it's a good fit, but also if it seems like there may be other ways that we can be supporting you, please let us know. We're happy to have those conversations as well. And our website's pretrial.org. We also have a help desk feature on there that if you just have any questions about anything related to the work that you're doing, that our TA providers can help out with, always feel free to reach out.
Thank you. We'll remember that. All right.
So
I
nice
think-
to meet you all.
Thank you very much. I think that finishes our meeting for today. Thank you
Judge
all. for
Garrett, this
being
is
here.
Jill here. This is,
Oh,
we do have
Jill,
one
yes.
attendee, so we need to invite. We have one attendee. If you'd like to speak to the work group, please virtually raise your hand now by selecting the raise hand icon. And no hands are raised. Thank you.
Thank you, Jill. Gosh, you know, maybe by the time this committee's finished its work, I'll remember those things. I never do. So thank you for being the backup there. They're having our back there. Okay, I think that finishes our meeting. Thanks to all of you. Our next meeting will be the first Friday in August. And I look forward to seeing you all there. Thanks again.
Thank you.